Item 1 permitted to withdraw, my lord.
Dismissed as withdrawn. All right. Item number 2.
My lord, on behalf of Mr. S.K. Dole, matter may kindly pass over, my lord.
All right. Supplementary list item number 3.
Obliged, my lord.
Your Lordship, I'm appearing on behalf of the petitioners. I seek time for this.
For what?
Your Lordship, this case this writ application has been filed for direction to Tahsil to dispose of the encroachment case number 260/2022, and Your Lordship.
All right. In case given the limited nature of the prayer, it is directed that in case the Tahsildar, the ED has not yet disposed of encroachment case number 2630/2022. Then he should do so in accordance with law after hearing all the affected parties by a reasoned order, not later than 1st August 2023. A copy of this order be sent to the Tahsildar.
Obliged, Your Lordship.
It may please your lordship, my lord. Your lordship, kindly come to page 22. I read in the writ petition that honorable tribunal may be graciously pleased. Page 22, your lordship.
Yes.
Allow the original application quash letter number 710 dated 9/4/2015 under Annexure 2 and further direct the respondent to recommend the name of the applicant to the Revenue Divisional Commission, Northern Division, Sambalpur, for consideration for promotion to the post of Orissa Revenue Service Group B by way of promotion for the year 2013, my lord. Then at the time of hearing, I filed a memo. Your lordship, kindly come to page 51.
Yes.
Annexure 4, my lord.
Right.
I not press the prayer for quashing letter number 71094/2015. My lord, 710 dated 94, in which 14 names were recommended by the collector Honorable for promotion to the post of ORS, Orissa Revenue Service Group B at page 30, my lord. 14 out of 14, 7 were given promotion, 7 could not qualify for promotion by the selection committee as provided on rule, my lord. This petitioner has 4 outstanding CCR to be recommended out of 5 CCR for preceding year of the recruitment year, my lord. 4 outstanding CCR, but they said that you have only 2 outstanding CCR, therefore your name has not now been recommended. I filed the CCR, my lord, in which the 4 outstanding CCR I had 2007, 8, 2008, and 9. Well, the honorable singular, what the honorable singular has passed the order under annexure.
No, but see the reply para 3 of the writ petition.
Yes, that is reply of the in rejoinder. I have given the reply, my lord, at page 48 and 47, 48, my lord. Outstanding CCR that was upgraded to outstanding. Your lordship, kindly come to page 47, my lord. Annexure 6 series.
No, I am asking you to read para 3 of the reply.
Yes, the reply I am placing, my lord. That. You 1 second, my lord. I am placing that. Only 1 second. That in reply to paragraph 6.5, for which his name was not considered by the collector to get promotion to the post of ORS. However, during the increments of the office of DSW, on so and so, my lord. Then your criteria, you lost in kindly come to next.
No. Just read on, sir.
Yes, my lord. That what they say very good for 2007 and 8.
You have not finished reading the entire paragraph.
Yes, my lord. I am completing that paragraph. However, during the increments of the office of DSW, Ongul and Tahsildar Ongul, both the officers have stated that he was very slow and quite inactive to deal with the work and was not satisfactory by letter number so and so dated 16/6/2013 and letter number so and so 2014 respectively. The letters have been annexed, annexure A and B for kind perusal, my lord. Then next para you lost it kind come to. That means
Last lines of the next paragraph. Out
Yes.
of 5 CCR.
now out of 5 CCR during the year 2007-8 to 2011-12, all the above said employees have a list of 4 outstanding CCR and the Rajkishore Sahu has only 2 outstanding CCR during the said period. My lord, I filed the rejoinder that those 2 years, 2007 and 8 and 8 and 9, at page, my lord, your lordship kindly come to watch 47, my lord. And 47, my lord, it was very good. I made representation. Then it was upgraded to outstanding, my lord. At page 48, 2007 and 2008.
So the others have 4 outstandings. You have.
I have 4 outstanding, my lord. 2 outstanding, they say. 2 very good have been upgraded to the outstanding at page 48. Your lordship kindly see on my representation. 2007 and 8 outstanding, my lord.
No, no, when was it upgraded?
My lord, it was upgraded on 17/4/2008. They suppressed that fact, my lord. Then your lordship kindly come to next page. This was outstanding, my lord. At page 49, you will also kindly see 49th page, 2008 and 9, and the upgradation is also confirmed outstanding at page 50, my lord. But Honorable Single Judge held that as I have not implemented those 14 portions, therefore writ application is not maintainable for non-rendered.
You are not interested.
I have no prayer against them.
All right. You say counsel, the appellant submits that he has no grievance against the 14 persons who have been recommended for promotion, and therefore did not seek to implead them as parties to his OA, which got transferred to this court after abolition of the OAT. So accordingly, he submits that the writ petition could not have been rejected on that score. He further submits that the only prayer that he was pressing was for a direction to the respondents to consider his case for promotion to ORS grade 2.
B, group B, my lord.
ORS group B. And in that context, submits that contrary to the stand of the opposite parties, that he had only 2 outstanding outstanding grades in his CCRs. He in fact had 4 outstanding grades, on par with others who had already been granted promotion. Paragraph. Notice, he accepts notice for the respondents. List on 10th August.
Item number 5.
Obliging.
My lord, in this case, my lord, senior counsel Mr. Jaswant Das is appearing, has some personal difficulties, my lord. Matter may be taken up 1 week after.
Only a review petition, sir. I don't know why we should keep the review pending. You are appearing for whom, sir?
For the petitioner, my lord, senior counsel.
What about service on the others?
Notice was sent, my lord, to private opposite party.
Confirmed, is it? The tracking report shows that copy of the notice was served on opposite party number 3. Stop. Now none appears on his behalf. Who's for the state? Counsel to the petitioner is stated to be in some difficulty today. List on 9th August.
Item number 6.
May I please, my lord? My lord, I am appearing through VC.
Yes.
I beg your pardon to submit something most important, my lord. This is not about item number 6. It is about the situation which is prevailing in Sambalpur city of Odisha yesterday, my lord. I may be allowed to submit something, my lord. It is very urgent. I may be disconnected at any point of time. I beseech your lordship to allow me to submit, my lord.
Who's printing you, sir?
Item 6 is mine, my lord.
I know.
Item
No,
6 is
it is
mine.
not for item number 6, my lord. I'm sorry. I'm so sorry. I really apologize for interrupting in between. I don't have efflux of time, my lord.
All
I
right,
may be
all
allowed
right.
to submit
Tell us what is
My
it?
lord, yesterday there was a bike rally of Hanuman Jayanti, my lord, in Sambalpur. And there was a serious situation which happened. And it is throughout the news channel, my lord. There was brick batting and forces were deployed. I really, the people herein are very in panic situation, my lord. Nobody slept. In my locality, even me, as a lawyer, I am feeling, I'm in very painful situation. Even the people.
So you can always, sir, you can file a petition even through email or online.
Tomorrow
You can file it even online, sir. You can even send an email. Send us a petition or something, even by email you can send, sir. Obviously, your internet is working.
No. This may be disconnected at any point of time, my lord.
It's all right.
There is no electricity. There is no electricity. I request your lordship to take so much cognizance of the situation, my lord.
So you please send us an email. Whatever connection you have, send us an email or a petition. You have enough resources to do that. Just get onto your net and do it. Just like you're appearing now, you please do it.
My lord, I'm sorry to interrupt, my lord, but this connection...
It's all right. No problem. Just, you have this connection now, just send an email. Send an email or a petition. Yes,
my lord. It may be...
It's all right, sir. It's all right. Just send it. No problem.
Item number 6.
Due to inadvertence, I have lost that case that day. And that is why it was dismissed, my lord. I am very much here, my lord. But unfortunately, I could not, because it is 63. I am wrongly informed that it is 65. I am submitting your lordship on 65 on that day, my lord. And your lordship, that is adjourned. But practically, it was 63 on that day.
I'm not able to understand what is saying.
My serial was 63, but I am wrongly informed that my serial is 65. Therefore, when 65 came into to the board, then I submit your lordship. But by that time,
what's the main matter about?
I have challenged the judgment of the learned single judge directing to pay all the retirement benefit to the respondent, number one, my lord. Even if disciplinary proceedings are initiated against him during his while he was in service, that is, he was retired in 2011, and disciplinary proceedings were initiated in 2003, and subsequently it was recharged, and that is disciplinary proceeding was initiated against in 2007. But and he was filed several writ application and contempt petition before this honorable court, and by this process it was completed by 2017, and by that time he was retired. Now he is taking plea that in view of Rule 93, he is not disciplinary proceedings cannot be initiated, and that is the only plea for which the honorable single judge has granted all the reliefs. My lord, he has taken loan, he has taken advance, he has taken advance from the office, but and he has also admitted 5 lakhs and odds to be paid, that he has appropriated 3,050 kilo of sugars during his incumbency as the senior manager in Kotak Manchester Godown in relating to sugar.
Was there any provision in the rules for continuation of departmental proceedings?
Pardon, man.
Please come to page 116 of the writ appeals.
Not
para 15. Come to para 15 of the impugned judgment.
Para 14 of? Impugned judgment. Yes, my lord.
Is understood?
Yes, my lord. The apex court in the case of Chandra Singh versus State of Rajasthan.
Para 15, sir.
Admittedly, no provision is there under Rule 93. Referred to herein above, which envisages continuance of the departmental proceeding after the retirement of the incumbent.
Is this factually correct?
Pardon, my lord? Yes, my lord.
Then what is your answer then?
My answer is, my lord, there are some admitted amounts which does not require any disciplinary proceeding.
Where's the question of if you can't continue the departmental proceeding after retirement?
No. My lord, the departmental proceeding is already completed.
When?
But he has preferred appeal as per the direction of the honorable court.
Did you complete it after his retirement?
Yes, that is after retirement.
Then it's illegal, sir.
Yes.
You could not have continued it after his retirement.
That I cannot dispute, man.
All right. You say, for reasons stated, the thing is recalled. and it's restored to file. Writ appeal, you see this repeal is directed against the order dated 28 September 2022, passed by the learned single judge, allowing writ petition civil 1162 of 2019, filed by the respondent. By the said impugned order, the learned single judge has quashed the disciplinary proceedings which were continued against the respondent even after his superannuation, and the corresponding punishment imposed in the said proceedings. Full stop. Consequently, the present appellant has been directed to pay all the retirement benefits to the respondent, together with simple interest at 6% from the date of his retirement within a period of 4 months, failing which there would be enhanced interest at 9% till the date of payment. Paragraph. Although disciplinary proceedings were initiated against the respondent prior to his superannuation, they were not completed for well over 10 years. The learned single judge has found that under the Odisha State Civil Supplies Corporation Employees Service Rules 1993, bracket the 1993 rules, bracket, there was no provision for continuing the departmental proceedings after retirement against employee after his retirement. Full stop. On that short ground, the entire departmental proceedings, paragraph. In the present case, admittedly, the respondent superannuated on 31st November 2011. Full stop. The departmental proceedings continued even thereafter and concluded with the order of punishment being imposed on 4th April 2015. Full stop. Following the ratio of the decisions in Bhagirathi Jaina versus DOD, OSFC 1999 3 SEC 666 and Chandra Singh versus State of Rajasthan AR 2003 SC 2889. The learned single judge concluded that in the absence of the provision in the 1993 rules, the continuance of disciplinary proceedings against the respondent after his retirement was unsustainable in law. Paragraph. Having heard learned counsel for the appellant, the court is unable to take a different view of the matter. Full stop. Admittedly, there is no provision in the 1993 rules that permits the continuation of departmental proceedings after the retirement of the delinquent employee. Consequently, the court is unable to find any ground to interfere with the impugned order of the learned single judge. The writ appeal is dismissed.
Item number 7.
None appears dismissed.
Item number 8.
May I plead your lordship? My lord, this is regarding that PIL matter I have mentioned yesterday regarding the upper age limit to be
Correct.
met to 38, my lord.
Correct.
My lord, yesterday the lordship was concerned about the fact that the order of the governor is not applicable on this.
Not binding.
Not binding, my lord. Yeah. My
Because
lord,
we have Article 309
yes, my lord.
and 229, I think. This
My lord.
Constitution of India, Article 229.
My lord.
The High Court makes its own rules.
My lord. My lord, before that, may I make one statement, my lord?
Yes.
My lord, it is a settled law that High Court is a state as far as the administrative
No difficulty
functions.
there at all, sir. No difficulty there at all. It may be state.
Administrative functions are concerned, yes, ma'am. Then, as per 309, my lord, the order given by the governor is applicable on the state.
No, that's a wrong logic, sir. You can't ignore 229. See, High Court is a separate organ, right? It's not bound by what the governor does.
My lord, if we go through 229(2),
Read
If we-
229(2). Read it.
my lord, 229(2),
Yes.
subject to the provisions that is, ma'am, I'm just concerned about that, provided that the rules made under this clause shall, as far as they relate to the salaries, allowances, leave or pensions, require the approval of the governor of
In
the
fact,
state.
we can have separate set of rules which the governor approves. It only
Completely
reinforces the point that we are not bound to follow the same rules.
completely agree, my lord. My lord, let's consider the situation. As far as this ASO recruitment is concerned, High Court does not have the absolute authority as far as the rules is concerned, because for these salaries, allowances, the High Court has, even the Chief Justice has to take the approval of the governor. That means the governor being the approval authority, even after the decision making made by the Chief Justice as per 229, is one notch higher than the
It doesn't
Chief
matter, sir. All this notch, higher, lesser, doesn't matter. Under the Constitution, we can have our set of rules, which of course it sent to the government for notification, so the governor approves. It doesn't mean that ipso facto, whatever the state government does, we have to do. In fact, this keeps a possibility alive that we can have our own set of rules, which the governor may or may not notify.
My lord,
But the governor has they've not said that you cannot have your own set of rules.
my lord, rules can be set up, but if we go through the governor order, that is 309, just kindly have a glance, my lord, annexure 2,
Annexure 2. All right.
page 16, my lord.
Yes.
At the last, it has replaced means through this amendment, it has stated that provided further that for advertisements made during calendar year 2021, 22 and 23, the said upper age limit shall be 38 years.
So whom does this rules apply to? That you have to see, correct?
My
This is
lord.
an amendment to the Odisha Civil Service fixation of upper limit rules. It is an
Yeah.
amendment to that, 1989, correct?
My lord, now let's see the rule number 2 of this Odisha Civil Service fixation of our upper age limit rules.
Right.
I have,
Right.
is the law.
Yes.
My lord, para 2, page number 2. Upper age limit for entry into government service. Notwithstanding anything contained in any recruitment rule regulating the method of recruitment in civil services and or civil posts in pensionable establishment under the state government, the upper age limit for entry into the government service shall be 32 years, except where a higher upper age limit has been prescribed for any such service or post. In this case, the higher age limit is prescribed, and that is 32 years. However, through this amendment, that is through Article 309, one section has been inserted. It has not been modified. It has been inserted, my lord, which states that provided further that for advertisements made during
So
calendar
all
years.
this applies to government service. There's no difficulty here at all. Show us do you have a case law which says whatever the government does applies to the High Court. This is not the first time High Court has conducted so many recruitments for so many posts. So many of them have been challenged. Show us anywhere any judgment which says whatever happens in the government ipso facto applies to the High Court. Then there's no need for giving power to the High Court to frame its own rules. The Constitution would make it very simple. It says, the Constitution simply say High Court is bound by all the state government rules. End of the matter.
That will affect the functioning of the High Court.
Good. So you realize that. So you realize therefore that ipso facto, if anything that happens in the government should happen here, there's a problem. Correct?
However, my lord, if
Show us any case law, sir. You are a lawyer, right? Or you've done
I'm
law.
in final year of law, man.
So anyway, it's a good learning ground. Do you have any case law to say that whatever the government makes as rules is binding on the High Court?
I am not making that submission that whatever government
If you
makes
don't,
rules.
sir, if you don't make that submission, then you're not bound to entertain your petition at all.
My lord, the governor's order will be applicable because if
Show us a case
229
law. Show us a case law that says I think the logic of your argument is like this: High Court is state. Correct? That's your first point.
Yes,
So whatever the governor does applies to the state,
not whatever the governor does,
or whatever the state government and gets approved by the governor that applies to the state. Correct? Throughout the state. That is your logic. And since High Court is state, it applies to the High Court. Like three-step logic. So show us any case law that this three-step logic flows from the reading of this 229.
my lord, there is no case law, but the wording which is written, any recruitment rule will cover the recruitment rule that is governed by this ASO recruitment. That is the High Court.
See, the basic flaw in the premise is presuming that the word state means everything under the state and that the High Court is under the state.
If High Court is under the state, then
that's a flaw there, sir, because you're overlooking what the character of the High Court is under the Constitution of India. We talk so much of independence, correct?
My lord, I am not talking about the judicial aspect of the High Court.
What else is there, sir? See,
Administrative.
Judiciary as an organ, judiciary organ has two wings. The judicial wing, the administrative wing. If the High Court has no power over its administrative wing, only government's rules applies to its administrative wing, there's no need for 229. What is the point in inserting 229 in the Constitution?
My lord, 229.
See, the nature of the service that people perform for the High Court on its administrative side is different from just a government job. The very nature of the service is different.
However, my lord, it is under 229.
And I must say that we extend as far as possible everything that you get in the government service here also. Like all the upper age limit for the special categories of persons. That is available here also. Whether it's for SCs, STs, women. So all those are applicable here also.
In state government ASO recruitment recently done, the upper age limit
So
was
it's the other
38.
way around. So the High Court is given the power to decide which elements of this state government's rules it wants to adopt.
That liberty High Court may not have. That is my submission.
So for that you have to develop. So you can't simply make a argument. You have to back it up with some sound logic.
My lord, the logic is the simplest logic that I derive is, as 229 does not give the Chief Justice complete authority.
The way of reading it, because you are today arguing, you saying it does not give.
My lord, only
you argue positively, it means it gives the Chief Justice the power to decide to what extent the rules of the state government must be adopted for the High Court. Read it positively. I
am only considering the part that salary and pension thing. That means if the Honorable Chief Justice is taking approval from the Honorable Governor, that means the Governor is in a higher position than the Chief Justice.
Higher, lower. So in a scheme of things, it has to go through a process.
The approval authority is.
We can turn that logic around. Every day the state government is before us. So many orders under the seal of the governor, under the signature of the governor are challenged before us. If the governor is higher, how are we squashing those orders? How are we interpreting those orders? See, you have to look at the scheme of things, right?
My lord, if we go through the Orissa High Court appointment rules, it is stated in para point 2 that if there is any discrepancy, then the Odisha's if the words and expression not defined in these rules shall have the same meaning as has been assigned to the Odisha Service
Yes,
Code.
yes. If there is ambiguity, there's no ambiguity here, sir. There's no ambiguity.
And as per 45, it says that that is the condition of service. It states that the provision of the Orissa Government Service Conduct Rules 1959 and Orissa Civil Service Classification, Control and Appeal Rules 1962 shall apply to the employees of the court, more fully described in Appendix 1.
So you're correctly now coming to that point that wherever the High Court thinks it should adopt the rules of the government, the High Court will decide that.
My lord, just one more submission, my lord. Let's forget this aspect. My lord, there was no amendment to the High Court rules 2029. I mean to say that in the advertisement 2021 of the AS of this Honorable High Court, the time limit given for the online application window was 31 days. That is exactly from 18th February 2021 to 20th March 2021. However, in this present 2023, the time limit is only given 20 days. As there is no amendment to the rules, this 35% reduction of the time limit is arbitrary in nature, and it may prima facie
Do you want to
suffice
know how
that.
many applications have already been submitted?
My lord, prima facie,
You have no idea. It lacks. It always election applications are in lakhs.
but prima facie,
So
my lord,
just for 20 days, we get lakhs.
then
That's also the desperate need for employment, because there is a problem there. Like we are advertising now for Group D. If we give more than 15 days, see, we have to also handle applications. I'm just saying we get lakhs just when you open it for 5 days and 6 days, we start getting lakhs of applications.
My lord, how come then last time?
And all of that is
31
online.
was given?
How is it that 1 lakh people are able to file those applications online in 5 days and 6 days, and you wait till the 21st day and then say it's arbitrary? There's some problem there, sir.
My lord, if something is different from the rest, then
No, you should test it.
my lord,
You should test it. Let's say, for instance, earlier recruitment, when we gave 35 days, let's say we got 1 lakh applications. This time, after giving 20 days, we've got only 10,000 applications. You will say, sir, see, obviously, people are not able to file applications because you've given such a short time.
that data I do not have.
Then there is a point. Here it's the contrary. We get more and more applications.
My lord, the reference that I am deriving, the difference of 11 days is hampering because as on 31st March 2023, the High Court Rule 2019 has been amended, where the upper age limit has been declared in a different way. At present, what has happened is that the 32 years upper age limit is calculated as on August 2023. And through this amendment dated 31st March 2023, it has been stated that the upper age limit will be calculated as on the date of the advertisement. So if we consider the past history and if we compare with the other government exams, I have attached around 4 to 5 exams. Everywhere it is given at least 28 to 32 days online application window. Had it has been given, because the High Court in its past advertisement has already given it, and there is no sufficient ground as per my limited knowledge to reduce it for this year to 20 days.
You're an applicant.
My lord, if given an opportunity, then I
No. I'm saying,
my lord, my
see,
age
I think
limit
you got
will-
knocked out on the age itself, correct?
Yes, if it is calculated
So
on
you bring forth a case of a person, let's say, who's 28 years old, right? Let's say he's in some Noapada or Baleshwar or wherever. You say, no, the internet has been down in Baleshwar for the last 1 month. Nobody in Baleshwar is able to connect to the net at all, not even through my phone. You show us the logs or whatever. Then we can take a call and say, let's say nobody has been able to apply from Baleshwar. Your address is Baleshwar. Not a single person has been able to apply from Baleshwar. So you say, listen, from Baleshwar, no applications have been filed.
My lord, for that,
So please give us more time.
my humble submission is that to answer that, I do not have the time.
So don't simply see
My lord, because if
one is to simply say by reducing 30 days to 20 days, grave injustice has been done. As a ground, you want to advance it, right? You want to say it's Article 14, you want to say it's arbitrary. But so there has to be some empirical backing up of that submission.
for that submission, then I need time, because
It's not the other way around, sir. When the court asks, then you start thinking about it.
my lord, just
You
my
should
humble
talk through this whole thing before making the submission.
my lord, just go through the timeline, my lord.
Oh, no.
The advertisement was ended
Sir,
on 28th.
There is a difference, definitely.
My lord,
But how
I
does
am
the difference
only
automatically make it arbitrary? That's the question.
my lord, just humble submission. Just 1 minute, my lord. The only tool I have is the RTI through which I can get these datas. And for that, in order to apply that tool, I need at least 30 days.
What RTI? Who's going to give you RTI?
How can I get the data? How many number of applications have been filed in 30 days?
See, how did you think of this ground? Obviously, you have consulted, you have looked at applicants, prospective applicants.
No,
Some of them have told you, without doing this basic homework, why do you file a petition, sir? Somebody must have told you, sir, this window for filing application online for ASO in the High Court shut early this time.
That
I was unable to apply because it shut early. You should have talked to 5 people at least. You can't simply walk into the court. When the court asks you the question, you say, oh, now let me go out and ask people. That's not how it works. It's the other way around.
My lord, if the days would have been 31 days, then the situation would have been a different.
What
altogether.
different? This is the whole point, sir. What different?
My lord, the difference is that the recent amendment made on 31st March 2023, the age limit selection criteria is stated
I
that.
think you're shifting from one point to the other.
My lord, I have only these 2 contentions I have stated in the very beginning.
We must admire that for a third-year student, you're doing far better than many lawyers. All right. I didn't expect you to withstand so much questioning. You're doing very well.
That definitely.
You have a brighter future if you're not an ESO.
It means so much to me.
No.
However,
it's important.
Just one submission regarding to this aspect only.
Yes.
The order dated 31st March 2023 regarding the amendment must have been considered in the month of March itself.
That's not how it works.
At that time, the recruitment was ongoing. Means 2 parallel things were going inside this Honorable High Court. One, already the recruitment advertisement for the said post and its eligibility criteria has been decided on 1st of March 2023. And parallelly, regarding that age criteria, some other aspects are also being considered by the Honorable Chief Justice. After which only on 31st March, amendment rule came and it stated that the upper age limit should be calculated as on the date of the application and not as on August 2023. My humble submission is that as 2 parallel things were going on the same time, then the thing which benefit the applicant should prevail and not to the recruitment authority. It is as simple as the employer-employee relationship.
All right.
Under this ground itself, if the Lordship can give me the remedy, my lord. My lord, it is as far as my limited knowledge is concerned, if 31 days cannot be drastically reduced to 20 days.
All right.
35% of reduction, my lord.
All right.
Because if suppose this is the last point, my lord.
Yes.
Suppose let's say that the probation period gets reduced during this course, then it will be immediately applicable to even to this batch, this current recruitment batch. So on that ground itself, if the age criteria has been redefined, then it must be applicable to this batch also, because these 2 things were going parallelly at the same time. Even if you consider that the 20th of March is the last date and the Lordship is not convinced to increase it to 31 days, then also it cannot be denied in my limited knowledge that 2 parallel things are going. So the thing which benefit the applicant the most will prevail.
All right. Thank you. The petition is dismissed. We'll pass a detailed order. We have to do some justice to your arguments. But really well done. Well done.
Item number 9.
Item 9, my lord, similar matters shall also as fixed to 8th May.
Yes.
Sarta Pradar.
Right, sir.
Item number 10.
10 also Sarta Pradar.
Right.
Item number 11.
11, my that Arlok Mishra case uses 24th August 23.
All right. Same order.
Item number 12.
12, my lord, Sarta Pradar.
Right.
Item 13.
Item 13,
My
14,
lord,
15.
item 13. My
Yes.
lordship, I am appearing on the behalf of Mr. Sambit Samman. He is not well. Kindly, my lordship, I am praying for 2 weeks time.
Wait a minute, madam. This is actually the appeal of the state.
Yes, sir.
You are appearing for the respondent.
Yes, sir.
1 minute. Counsel for the respondent. 6 time to address arguments. Interim order to continue. What is this batch of matters?
My lord, that 13, 14, 15, 16, 17, 18, 19, 20, 21, 22 and 23. All are laboratory technician matters. So leading case is item 16.
Malani, item 13 and 13, 14 and 15. I am filing my UCLA now for respondent, my lord.
All right. So we can have all of this on a separate date.
Sorry, my lord.
No. This entire batch can go on a separate date. Then.
The only one day today, the lordship fixed to all the matters today. So in some cases, some have appeared. In some cases, notice has not issued.
Notice,
The leading case, item 16 is the leading case. There, my learned friend, Mr. Shao is appearing. If your lordship will take up that matter, and the issue can be settled.
So 15, for instance, you are appearing in 15.
I am appearing in 13 and 14, my lord.
Okay, who's appearing in 15?
15, I am instruction to appear, my lord.
Okay, all right. So he has instructions to appear in 13, 14 and 15. Madam, you're in?
You must. I am in 13 item.
13, all right. Who's in 16?
Mr. Shao.
16, my lord,
Two
there are
matters
2
are there.
items. 2 items in 16. The second one I am appearing, and the first one my
one?
brother is appearing.
Second matter is the leading matter.
And another case is item number 90. The same laboratory technician. Today I am also appearing in item 90.
All right. Basically,
Same.
then everybody is represented. All the respondents are represented.
Your lordship may fix the date.
Some other day.
My lord, I have filed my UCLA in 13. I think madam is mistaken, my lord.
No, sir. I am appearing from Mr. Sambit Samman.
No. I am appearing for respondent. That is an item number 13.
Which is the item case number in which you are appearing?
It is item number 13 for the
No. Case number. Tell us. Writ appeal number what?
Perhaps
That
that
is
single.
2581 by 2019.
No. That's a different list. You're in the wrong list. That's a single judge's list. Awesome.
Sorry, my lordship.
That's all right. Yes.
Your lordship can 13, 14, 15 up to 21. And 90 may be also added. 90 same laboratory technician, and today I am appearing in 90. Last item of the today list.
All right. Counsel respondents or seek time to address arguments in all these matters. So you bunch all of them together.
And
23 also.
And other matters, may I give the numbers?
Yes, give the number.
Yes, ma'am. That's item 47, 48.
I think 20th July seems to be fine. 20th July, sir. 20 July.
Yes.
Interim orders to continue.
my lord, in item 23, senior, yes, he is also appearing. Mr. S.B. Jana.
Respondent, ma'am.
23, same matter.
Yes, my lord. Our name is reflected, my lord, in item
Your
number
name is
23.
appearing.
Just give all your appearances so that's easier for him to note off. put down in a slip of paper all your appearances.
Man, the lordship fixes July, man.
20.
Item 19 may be taken over as the leading matter, my lord. Item 16 may be taken over as the leading matter.
That's all right. It will all be shown together in the list when it's called out that day. You can easily say that you want to start arguments in that matter. No problem.
Second matter. Right.
So item number 13 to item number 23, item number 47, item number 48, and item number 90.
90, yes.
Item number 24.
24, a similar matter, your lordship has fixed to 25th April.
25th April. All right.
Item
Condonation delay, I have already entered caveat in this matter, that condonation of delay petition may be sought upon me so that I will file my objection to that.
Sir, all this is COVID period, can get condoned anyway. So, because Supreme Court order is there. So no point. We can today itself condone it. Actually, we'll save you the trouble. IA 3457 for the reason stated, the delays
Some
control.
cases after COVID period, COVID period is over, after 1 year also they filed.
Well, actually, that Supreme Court order takes it to, I think, end of 22.
Yes, my learned friend is saying after that
Supreme
period.
Court order carries it beyond.
First, the June that covers.
Correct.
He's saying that June is
My
not
lord,
yet
what
come.
happens by taking such opportunity, the cases which were disposed of 3 years, 2 years back, now the writ appeals has been
Fine.
floated.
Correct.
That is
Anyway. All right. That release condoned in 24. All right. List on 25th April.
Item 25.
25 also same.
Same.
Item number 26.
In 26, lordship has issued notice on
I think they
16th.
didn't serve, no? Tracking report 26. What is this matter about?
Same case, that old pension that we also fixed it to 25th April.
25th April.
Item 27.
27 and 28 were not same. 25th of April.
in 27, I am appearing today, my lord.
So put down his appeal cases. See, please give you a slip of paper here with your names. Actually, we should prepare. Delhi High Court. We used to have a
Item number 28.
28, 29, 30, 31, 32, 33, my lord. 25th of April.
all right.
Only one difficulty, my lord. Item 33, my lord. The noting has come that the notice could not be issued with non-filing of postal requisition. We have already done it. That's right.
Item 34.
Well, lord, in item 30, 31 also I am appearing today. 30, 31 and 33. I filed the Binama.
Okay. 34 is 24 July.
34 and
25 July.
No, sir.
Item
Don't
30.
confuse. We are now in 34, item 34.
Sorry.
33 is 25th April. Your wakalatnama is taken on record. All that is over. Now, Mr. Rao's matter.
34 and 35, both.
24 July.
Item 36.
36, my lord. 30th of 38, 2023, my lord. Rehabilitation assistance.
30th August.
Item number 37.
37, my lord. 25th of April, my lord. Regularization of DLR employment.
Item number 38.
38, my lord. Work charge employee 14.9.
14.9.
Item number 39.
So, Union of India.
The passport authorities have challenged the judgment of the single judge wherein the application for Tatkal passport was applied, and upon police verification it is found that there are 2 number of criminal cases pending against the writ petitioner. Therefore, he was asked to appear before the passport authorities for verification of documents. Instead of appearing before the passport authorities, he has approached this honorable court and has obtained an order that by furnishing an undertaking, he should be issued with the renewal of the passport. That order is not challenged because the requirement is that.
So the order is 1 year ago. The order was passed 1 year ago.
Yes, what happened after we have filed an application for continuation of delay for
No, forget here.
and the whole difficulty is that in that case a order has been passed in a blanket order that whenever a person is on bail, passport is to be granted in his favor without verification or things, all these things. That is why after this judgment, several cases has been orders has been passed following this judgment. We are in difficulty to.
No, but have you complied with this judgment or not?
What happened in the meantime? Tatkal application was rejected on the ground. It cannot be issued Tatkal in your favor. You apply in a regular manner. He has applied for regular manner. Regular passport has already been issued in his favor.
Then we'll just say it won't constitute a precedent.
Now, whole
We
thing
will only
is that,
say that this will not constitute a precedent.
yes, that is
Say
what
counsel for the appellant states that pursuant to the impugned judgment dated 23rd March 2022, an order was passed to the effect that the respondent is not entitled to a single quote tatkal unquote passport, but he was permitted to file an application for a regular passport. Full stop. It is further stated that pursuant to such application, respondent has in fact been issued a regular passport. Paragraph. In view of the above developments, the impugned judgment, the present appeal is in fact, peculiar to the facts of the case of the respondent, infructuous. Nevertheless, counsel for the appellant states that several other writ petitions have been filed, claiming similar relief, where the impugned judgment is being cited as a precedent.
even for getting the normal passport.
In that view of the matter, it is clarified that the impugned judgment will not be constituted, will not constitute a precedent, and will be treated as having been passed in the peculiar facts and circumstances of the case. The questions of law arising from the said impugned judgment are left open for decision in some other appropriate case. The appeal is disposed of.
Item number 40.
My item 40 is up counter 14th September.
14th September. All right.
Item 41.
41, 42. Or 43 LRC may take up this matter next any day.
No, what about 41, 42?
41, 42, 14th September.
14th September. 43, at the request of counsel for the appellant, list on 1st May.
In that case, my name appears before the tribunal, so I can.
All right.
Item number 44.
44 works till 14th September.
All right.
Item 45.
45, 45, 46 rehabilitation.
30th August.
30th.
48 already taken. Item 49.
49, 38, my lord, rehabilitation assistance scheme.
30th August.
Copy.
Item
Copy of the
50.
written.
Copy of the written.
Item number 50.
50, my lord, work charge employee 49.
Right.
51.
51 on DLR regularization matter 25th of April.
25th April.
Item number 52.
52 rehabilitation assistant matter 38.
38.
Item number 53.
53 matter that laboratory technician matter that 20th July.
Item 54.
Job contract 14th September.
Item 55.
Lord, work charge employee 14th September, my lord.
Item 56.
56 job contract 14th September.
Item number 57.
That is also job contract. 57, 58, 59, 60, 61, 62, 63, 64, 65, 66, all are job contract 14th September.
All right.
Item 67.
So also 67, 68, 69, my lord. Same.
Work charge.
My lord. JC employee, job contract.
1470. Item 70.
My lord, 70 rehabilitation.
30th August,
Item 71.
Sartapata 8th May.
8th May.
Item 72.
72, my lord, the lordship has fixed similar matter to 3rd May 2023. That is WA number 1745 of 2020.
All right. 3rd May.
Item 73.
Rehabilitation number 30th August.
74.
74, my lord, that's a contractual matter. Your lordship-
74, my lord, identical matter government has already implemented. Similar case, same establishment, Director of Treasury, peon regularization of a peon, my lord, in the district treasury. And similar matter has already government implemented. You will also kindly have a glance by virtue of the order of the honorable court, man. That is WPC OSC 2720 of 2016. And 3 persons, they have been regularized. Kindly have a glance to last 3 pages by the office order 22/3/2023, madam, of same establishment, Director of Treasury, madam. And here the opposite party, he is also peon in the district treasury Jaspur. Honorable Single Judge has directed for regularization after completion of 6 years of contractual service. Now they have, and the point of discrimination is there, madam. You also kindly see in one hand, they have already regularized in similar circumstances person. Now the
I'll take instruction 5.
Counsel for the respondent has produced before the court documents to show that the orders passed in similar cases by the learned single judge on 13 September 2022, bracket WPC OAC number 2720 of 2016 dash Tapan Kumar Barik versus State of Orissa, bracket, has already been implemented by the government by issuing office orders dated 17th March, 20th March, 22nd March and 24th March 2020. Counsel for the appellant state seeks time for instructions. Let's stop. When are the other matters coming up?
That my 11th July.
11 July.
Item number 75.
Adjourn to 11 July. Adjourn to 11 July.
Yes.
Oh.
Item number 75.
Defect in course of the day on behalf of Mr. NC Dasman.
All right. List on 2nd May. Defects be cured in the meanwhile.
For admission, item 76.
My lord, item 76, kindly give a one pass over, my lord. Senior is on the way, my lord.
Item number 77.
Yep. In this case, my lord, as per the order of this Honorable Court, yesterday they have sought the copy of the affidavit filed by the IIC. And they have stated in that affidavit that the case is not proceeded enough. And there is the absconding accused person still yet, and no step has been taken for attendance of the absconding accused persons. Though they have admitted the 19 accused persons are in absconded. And the case is the year 2012 and
An affidavit has been filed. Affidavit dated 10th April 2023 has been filed by the IIC Latur Police Station. We state that GR case numbers 35 of 42, 28 of 40, 28 by 40, and 33 by 41 of 2012-21 are pending the court of the ADJ Patnagarh. And the cases have now been posted for 20th April 2013 for appearance of two of the accused persons who had not attended the earlier date on 5th April 2023, despite summons, and for the production of 19 absconding accused persons. So, charges have not yet been framed in these cases, but it is assured that expeditious steps would be taken to examine the prosecution witnesses after charges are framed. A direction is issued to the ADJ Patnagarh, seized of the above cases, to proceed to the stage of framing charge as expeditiously as possible. As far as GR case number 31 of 2012, pending the court of the SDJ in Patnagarh, appearance of 91 of the 109 accused persons was pending till 4th April 2023. 16 are still absconding, 85 have appeared on 5th April 2023, and the trial against the absconding persons has been split. It is assured that by 30th June 2023, 22 PWs will be examined, and the entire trial is expected to be concluded by December 2023. Paragraph. A further updated affidavit be filed before the next date. List on the PL. July.
Hello?
17th July. Item note 78.
My lord, this is about illegal slaughter of cows and transportation of cows outside the state. My lord, in the last order, CMC was supposed to file an affidavit. My lord, they have not filed anything, but may I suggest something, my lords? Is that now the Ramzan is going on, it's a sensitive issue. So maybe we could adjourn it to a date beyond Eid or something. And in the meantime, if CMC could file its affidavit.
Yes. See, the CMC is yet to file an affidavit. An affidavit be filed by the CMC positively within 8 weeks. List on. Give me that. 18 July. 18 July.
Item note 79.
79, man, kind of a glance to order number 27. Miles directed the state government to file an affidavit pursuant to the order dated 22nd August 22.
Village Surveillance Committee.
We have not.
Or at Mr. D.K. Mahathi seeks and is granted a last chance to comply with the order dated 22nd August 2022 and file the affidavit positively by the next date. Just on 19 July.
Item number 80.
My lord, on behalf of K. Pradhan, kindly taken up next.
Item 80, your lordship may see the report has.
Read SW0.
I'm just giving. Hey, report. Just submit. Your lordship has directed the DSW of Puri to submit the report. That report has come. I think it is also sent to the court directly.
Yeah, it may have been said. See, all right, stand. An inquiry report has been submitted by the District Social Welfare Officer, Puri. My lord,
Should I submit a copy?
2023.
Should I submit a
Yes,
copy?
yes. Copy thereof has been handed over today in court to counsel for the petitioner, who needs time to examine it and make submission. List on 28th July.
Next.
Item 81.
My lord, pass over, my lord.
All right.
After all, sir.
No. Take come up now, sir.
Item number
Next
80.
week, next week, my lord.
What is the matter about? What is the matter?
My lord,
Shri Shibananda Satpati. Let's just see what it is.
Vigilance Department has also filed the counter and we have also filed.
OP number 6 has required to be filed, my lord. Only 1 and 7 file their counter, my lord, and also 8.
OP number 6, vigilance.
No, OP number 2 and 7 file counter.
Yes.
8 also file counter.
Yes. 6 also file counter.
7 is required to be filed, my lord.
No, already filed, sir. 2 and 7.
CDPO.
9, my lord.
2 and 7.
It's okay. Whoever is filed.
Collector is CDPO same.
We can't compel people to file.
No, my lord, 9 should be required to be filed. My lord, I am challenging the food analysis.
If they don't file, we can't compel them to file.
No. My prayer short time to file.
9.
My lord, last time for filing reason. Last time, my lord. Last chance, my lord.
All right.
Actually, they are required to file rejoinder today.
Last chance to file.
They are insisting.
The last 2 occasions they had taken time to file rejoinder. They are not filing rejoinder.
Twenty-fifth July.
Obliged, my lord.
Item 82.
My lord, I am appearing for the State Pollution Control Board. Well, we have already passed the order on 21/9/2022. The Lordship has directed that if any dispute regarding pollution he should approach the state NGT on 21/9/2022. 21/9/2022, your Lordship has passed the order that if any dispute, because similar case your Lordship has disposed of, that is WPC number 11970 2012, same villagers have approached this honorable court.
Please, your Lordship, may I make my submission?
Yes.
Yes. Your Lordship, my final submissions today would be based on the counter affidavit which has been filed by the state opposite party number 3.
1 minute. You've got the rejoinder, Mr. Mohanty? She has filed the rejoinder. Have you served a copy, Ms. Latif?
Yes.
How did you serve it? By post?
My senior.
He has told me to file the rejoinder. I filed it on behalf of her.
No. Whether he has got a copy, that's all I want to know.
Government copy I have served. I don't know.
We have filed the counter on 28th.
No, sir. Rejoinder
Copy I have not been served.
For copy number 4.
That is
he is the state, sir.
So the state I have received. I have already served him, Lord.
You please
rejoinder.
Give him another copy, sir.
Okay, I will give him this. Because I have rejoinder. I have already served a copy on.
All right. Another copy of the rejoinder be served on Mr. Mohanty.
Your Lordship, my argument today.
No, but he'll have to have a copy, Ms. Latif. You can't. He'll have to go through it, obviously.
Just on the basis of the counter affidavit, I want to have my
It's okay.
final.
It's all right. You've said so many things in your rejoinder now. I can see that.
Yes,
All right.
Your Lordship.
All right.
Lordship, short date may be granted.
Short is not possible. It'll have to go after the
Number 2.
list on.
I have also not been served with a copy, ma'am.
All right.
I'm
He's there,
giving
he's right there.
Yes, I'm coming in half an hour. I'm serving them.
All right. All right. 13th July. 13th July.
Item number 83.
In this case, petitioner seeks to assail the order of the Honorable Single Judge, dismissing the case of the petitioner. The case is that initially the petitioner was appointed as a tax collector in Konarka NSC. Then thereafter, in 1991, Lord, post was created in the rank of the junior assistant. The rule at that point of time, Lord, to fill up that promotional post was Rule 7, read with Section 75. Rule 7 envisages that at that point of time, your Lordship will kindly bear it in mind that there was no common cadre of the feeder post of the tax collectors throughout the state. Every NSC urban local bodies was free to appoint their own persons in the class 4th. Then the rule 7 was that a selection committee will be constituted, which will go into the matter of selection and select the person to be so appointed in junior assistant, though the junior assistant post was an LFS cadre. Section 75 provided the manner of constituting the selection committee. A duly selection committee was constituted and the petitioner was selected and was appointed. He continued in the said post and immediately prior to creation of the post, sanction of the government was obtained, and immediately after the appointment it was intimated to the government that urban housing and urban department that such and such person has been promoted and he has been appointed to the said post. The matter was kept pending there. Then in the year 1996 came a circular that those persons who have been appointed in between 80s and 92, they have to face a selection test, and for them the circular was issued to all the local committees to forward the names of such appointment. The petitioner's name was also forwarded for such selection. But the petitioner was not permitted to appear, and when the list was published, petitioner didn't find his name and then approached this Honorable Court. Honorable Court directed that he may prefer a representation. The representation was rejected, and then again the petitioner has approached this Honorable Court in this writ application, out of which this writ application arises. My Lord, in the writ application, my Lord, while considering the case, my Lord, the Honorable Single Judge held that he didn't find fault with the selection committee and other things. He said Rule 9, and he says that the prior approval of the government is necessary, and the prior approval has not been granted, my Lord. In the meantime, my Lord, years has elapsed, and the petitioner has passed the accounts exemptions also, and he was treated as a junior assistant, and he was transferred out from the Konarka NEC to other NSCs and municipality where he was posted. But the Lord Singh judge held that no, the appointment is irregular, and therefore the rejection of the representation is valid and justice. But as a result, he is still now working in that junior assistant person. He has been granted RSCP and other benefits from time to time. 31 years thereafter, Bernard, he is not being regularized. That is the case, my lord. May I now place the honorable single just order, my lord?
No, so you are agreed by the non-regularization or by the reversion?
Well, reversion meaning non-regularization.
No, because you are now a junior assistant only.
Yes. I am continuing because of virtue of your lordship's interim order, my lord.
No. So you want regularization as junior assistant?
Yes, my lord. Otherwise, my lord, I will not be getting the pensionary benefit. You know, I am on the verge of the retirement.
So let's see the impugned order of the single judge.
My lord. Page 212. I have more time.
Para 11, can you read? 212.
Well, can I read from paragraph 9, my lord?
All right.
The crux of the issue is as to whether promotion of the petitioner from the post of tax collector to the post of junior assistant is legal and valid. Rule 7 and 9 of the Orissa Local Fund Service Rules 1975, which are relevant, read thus. This section 7, the section of all selection of all posts in the service, whether created or fallen vacant, shall be made by the selection committee constituted under section 75 of the Act for the purpose, and a copy of such selection order shall be sent to the council for appointment by appropriate authority. A copy of an appointment order shall be sent to the Director of Municipal Administration. Then promotion of employees, Rule 9, my lord, shall normally be made from amongst the incumbents of the particular cadre with concurrence of the Director of Municipal Administration as per provision in the rules. If no suitable candidate is available within the service, the recruitment may be made from outside in the manner prescribed in Rule 7 after obtaining prior approval of the Director of Municipal Administration. On a conspectus of the old rules 1975, it is evident that selection of all posts in the service, whether created or fallen vacant, shall be made by the selection committee constituted under section 75 of the Act for the purpose. It is mandatory that appointment order shall be sent to the Director of Municipal Administration. Rule 9 of the Rules 1975 provides that promotion of employees are normally made from amongst the incumbents of the particular cadre with concurrence of the Director of Municipal Administration. Though Rule 7 was amended and thereby selection committee was substituted by the selection board, but the fact remains that prior to amendment of Rule 7, concurrence of the Director of Municipal Administration for promotion is a sine qua non. Under Rule 9 of the rules, no concurrence of the Director.
Actually, do you have that ML Keshari judgment? State of Karnataka versus ML Keshari. You have that judgment. There's a distinction made between irregular appointment and illegal appointment, where the Supreme Court has said merely because the appointment is irregular, he will not be denied regularization. ML Keshari.
Yes,
State of Karnataka versus ML Keshari. Following Umadevi.
Yes.
After Umadevi, there's been a string of judgments following this para 7 of that ML Keshari, which makes a distinction between illegal and irregular. Something like this will be irregular, will not become illegal.
I am given to understand your lordship has also delivered a judgment.
Yes.
In that way.
Yes.
I haven't got those.
Just look at that. And there's a whole 4 judgments following this ML Keshari. And this is a classic case. He's put 31 years.
And now that further promotion chances are gone, even though he has passed out.
Naturally.
His services has been utilized throughout these years in different NSCs. Now he will retire and get class 4 benefit only for pensionary dues. Well, your lordship may adjourn it for short adjournment so that your lordship is posting it after August and other things. May I pray that it may be before vacation. Any that is convenient to your lordship.
All right. We see at the request of Mr. Ashok Manti, Senior Counsel for the appellate list on 15th May, sir.
15th May? Obliged, my lord. Interim order to conduct.
Interim order to conduct. All right.
Item number 84.
My lord, on behalf of Shishir Kumar Purohit, delete my name from him, sir.
What's he saying?
The respondent.
Who's for the appellant?
I am for them. In this case, I have already filed a debt chart and also the memo of citation with the rules there.
All right. You're for the, who's for the institute?
Him, sir. Yes.
Him, sir.
What has happened to counsel?
Delete my name. On behalf of Shishir Kumar.
You have appeared for Vimsa. That is the contesting party.
All right. Today, counsel appearing for the respondents. That is, what's your name, sir?
Nihar Ranjan Panda.
Nihar Ranjan Panda states that their name should be deleted as they are no longer appearing for the. What do you do? Fresh notice, you'll have to go.
My lord. My friend is properly. You are saying to me, some other counsel has entered appearance for them.
Who has entered?
Then let them give the name. So
who has entered appearance?
Mr. Purohit. Let me take instruction from Mr. Purohit because he's a new entrant. He might not. If somebody will be there, I will take the burden.
The respondent will now make alternative arrangements. List on. June 26th June.
May I submit, my lord? I will take instruction from Mr. Purohit. If somebody else, he is not given me the name, then I have to take notice. Can it be next week so that I can take notice again?
Or let's go notice. You say notice now be issued to the respondent to make alternative arrangements. Returnable 6/26 June. Best.
That is better.
Yeah.
Item number 85.
85 minutes. I'm appearing on behalf of the respondent minutes. I pray for similar order minutes in respect of the
capital.
The
data entry operator, my lord.
Not data entry operator. Working as system analyst. System analyst.
All right.
Only one prayer minutes. It's status quo till as on today to be maintained till the disposal of the writ application.
All right. We add a line here, status quo to be maintained till then.
Grateful, madam.
The end of para 3.
From 86.
No, it's 86 and 87, my lords. This will go to 8th of August, my lords.
All right.
Outsourcing.
All right. Item number 88. 88. 88, my lord, is old pension rule, my lord.
14 September.
My lord.
No. 25th April also. 25th April.
25th April, my lord. Yes. Item 89.
It's 89. It's covered by a lordship's judgment passed yesterday, my lords. Item number 2, my lords. Data entry operator on
Tassels.
Yes.
All right. In view of the judgment in Patita Pavan.
Grateful.
Appeal is dismissed.
Grateful.
90 is over.
Pass to matter item number 2.
Item 2, my lord. Petitioner enclosed the land.
Sorry?
Petitioner enclosed the government land. It is file a repetition before the authority Tahsildar.
Correct. Where is the proof of making the representation?
File a repetition, my lord.
Proof of submitting the representation. No proof is there, sir.
On behalf of Mr. Kindly any other day.
Here, my lord, it appears from the writ petition, the husband has encroached upon the government land.
Oh.
Wife has filed this application for demolition eviction. And
husband versus wife.
My lord, some other person, those have been implicated as opposite parties. When they encroach upon the land, this petitioner showed the path of encroachment. When they encroached upon, therefore this petitioner has come before this honorable court for eviction of those persons.
I see.
Purely personal interest, no public interest is
involved. There is no proof of the representation at Annexure 5 being submitted to the Tahsildar. Krishna Prasad. Stop. Where did you get this that the husband is the encroacher?
the Annexure 3 series, my lord, that is in Odia, my lord Babula Pallei, the husband of the present petitioner, your lordship may kindly see the court's title.
All right. Counsel for the state points out that from Annexure 3 series, it appears that there is in fact a dispute between the petitioner and her husband, which is now being projected as a PIL paragraph. For the aforementioned reasons, the court declines to interfere. The petition is dismissed.
Well, kindly direction to the Tahsildar to inquiry properly.
No, sorry. Yes.
Pass to matter item 76.
Which one?
Well, in item number 76, I'm appearing through VC. Well, this is a matter where your lordships in a review petition had issued notice and brought to the state.
Correct. Who's appearing for the other side?
We have, sir.
But you have to give this to the Mr. Mishra. You have got a copy of this note.
No, my lord, I haven't got a copy.
Give him a copy, sir. You have to send him a copy.
No, your lordships. This has been filed on behalf of the petitioners.
Oh, I see.
This is a note of submissions on our behalf.
Oh, I see.
Because we have served a Dasti on the opposite party number 3.
No, I think they're appearing.
My lord, 5 engineers services were dispensed with. If your lordship will straight away go to paragraph 9 of that written note. Out of the 5 engineers whose services were dispensed with by the petitioner management, 2 of them raised an industrial dispute. That is opposite party number 3 and another employee. The learned labor court, which is the present matter, Bhubaneswar in ID case number 04 of 2000 by order dated 26/7/2018 held that the action of the management is illegal and unjustified and an order of reinstatement and full back wages should be proper relief. And this order was challenged before your lordship in the writ petition. Now, another engineer raised an industrial dispute before the industrial tribunal. If your lordship will look at paragraph 10.
Yes.
And this is ID case number 13. And that order is in the additional affidavit, which was filed in writ petition number 5671 of 2019 at page 5. And this is the observation of the industrial tribunal, which I have quoted there.
Right, right.
As far as this engineer is concerned also, he was drawing a salary of 2,19,804 per year. That is at paragraph 3, undisputed.
Right.
Paragraph 3 of that written submission.
Right.
Now, in fact, the other person who went to the industrial tribunal also challenged that order before your lordships, and that order, your lordships that has been dismissed as withdrawn on 22/9/2022. That is at paragraph 11 of my written note.
Right.
Now, all these persons were identically placed.
Right. What do you say, sir? In those cases, they were held not to be workmen.
That is not the case, my lord.
Meaning?
Because the another workman has raised the industrial dispute, that supervisory and workman definition, my lord. In this case, it has been, there is a material available on the record. The court has held that it is a workman.
That's what he's saying, inconsistent orders. Same engineers, there are 5 engineers. In respect of 2 of them, it's been held they're not workmen. And in this case, they've been held to be workmen.
Well, that point they have only filed in the High Court, my lord. They're not raised before the tribunal.
Whatever, sir. The question is that in 2 cases, if they're held not to be workmen, isn't it inconsistent as far as the present case is concerned?
Well, in my case, there is sufficient material to establish that he is a workman, my lord. In my case. And that case, my lord, what is the material placed before the tribunal, I can't say, my lord.
What we can do is...
My lord, it is almost
heard, sir.
re-hearing of the case, my lord.
No, let it be properly heard.
My lord, first, I have got to discern this point. The scope of review is limited. They cannot take re-hearing of the matter.
Not for re-hearing.
My lord.
See, this impugned order was passed on 20th September 2019.
I have given the judgment, my lord, of the Supreme Court recent judgment, my lord. It is amount to re-hearing. The sufficient material. Lord, come to that findings, my lord, of the division bench, my lord. That finding he want to challenge again in the review, my lord. He can take all things in the appeal, my lord. Not in the scope of review, it amounts to re-hearing of the case. That point they have raised. And your lordship, page 19 of the impugned judgment, your lordship, see.
Yes.
Let's come to page 19, my lord. The second paragraph, my lord. That's 2S of the...
Yes.
For better appreciation of section 2S of the Industrial Dispute Act, the workman means the definition has been quoted, my lord. That was the Apex Court in the Rishona's report, 94 Supreme Court, held that a determining factor of the main duty of the employee concerned does not some work incidental done. In other words, what is the substance of the work which the employee does, or what is the substance is employed to do, viewed from the angle. If the employee mainly doing the supervisory work, but incidentally, for a fraction of time, also does some manual work or clerical work, the employee should be held to be doing supervisory work. Considerably, if main work is manual, clerical or technical, nature, the mere fact the same supervisory work
or is also done by the employee incidentally, only small fraction of work is being devoted to some supervised work, the employee will come within the purview of the workman, my lord. The court below rightly recorded the findings that second party is a workman as management failed to prove the nature of duties. Thus, it cannot be said that it is come within the purview of the workman. The labor court has rightly passed the award. Direct there is no stipulation that there is contractual agreement or appointment. All these points raised by the learned counsel for the purpose petitioner are answered accordingly, my lord. Then second part of the appeals court in case of such and such, it is held that findings of the court recorded by the tribunal cannot be challenged in a proceeding in the writ of certiorari on the ground that relevant material evidence adduced before the tribunal was sufficient, inadequate to sustain the impugned findings. The adequacy or sufficiency of evidence led to the point of interference of the fact to be drawn from the said findings within the exclusive jurisdiction of the tribunal. The said point cannot be agitated before the writ court. The aforesaid settled principle will still hold good. Said principle was reiterated in the decision reported such and such pilot. That ground sufficient material is there. Though this court again cannot take a view, my lord, second view. And those cases, the materials may not be available before the tribunal.
Do you have the order dated 22nd September 22?
22, my lord,
No. They are relying on it. This court's order dated 22nd September. In the other case.
I'll produce it. That was dismissed as withdrawn.
Oh, dismissed as withdrawn. All right.
Yes, sir.
So there was no finding as such.
No, my lord. They were claiming for back because I appeared in that matter also.
Right.
And
so it's a subsequent development, sir. So the question is, this can't be an error on the face of the order dated. This can't be. This doesn't fall within the purview of a review. Then it's not something that could have been brought to the notice of the court to persuade it to come to a different conclusion.
No, I'll just tell you, lordships. There are two orders. I'm not on the question of the factual aspects. Admittedly, there are two orders. 5 engineers were their services were dispensed with. 2 orders, one of the labor court, one of the tribunal. Contradictory orders. Now, whether the workman comes under the definition of 2S was decided by the industrial tribunal saying that no, he does not come. And the other one, labor court says, yes, he comes. Now, I come before this honorable court. Now, if your lordships will look at it, now your lordships are not bound. Your lordships may be bound in terms of the Yakub judgment with regard to the certiorari. But when there are 2 conflicting judgments, passed one by the labor court and one by the industrial tribunal, your lordship surely has the power to review the order if it is inconsistent. Because it's the same organization.
No, it can happen the other way around too, right? Because the order of the labor court was 26 July 2018, whereas the order of the tribunal was 30th March 2019.
Yeah.
So it can be
that is why we produced that before the learned before your lordships in the first round of litigation. But if your lordship will look at that order, your lordships have not recorded any finding with regard to the industrial tribunal order. We produced that order. And that is the error.
Achha, you produced
the order. If your lordship will look at that order, we have filed that by way of an additional affidavit.
Oh,
that order has not been taken care of or has not been discussed by the High Court at all.
I see.
And that is why we came in review, saying that there is an error apparent on the face of the record.
Oh, I see. That's the only point then.
That cannot be. They have
no. Once there is an additional affidavit,
in the read court, the scope is limited, my lord.
But there is a material placed in record which the High Court has not dealt with.
The labor court, on basis of available material evidence, has come to conclusion that I am the workman, my lord.
See, identical post, same company. Another
materials must
person
be-
has gone before the
Lord,
tribunal and not succeeded.
My lord, material must be available before the tribunal.
That's right. We don't know what was the material.
My
So
lord,
unless that's
in
discussed.
that case, what material placed?
That's what. So the
My
order
lord,
is
that-
placed.
Also, these points they have not raised before the division bench.
No, they have. They
No.
find an additional affidavit. No, that is true, sir. Just look at your writ petition paper book. An additional affidavit has been filed. This was raised before the court.
My lord, they have raised, my lord.
Not raised with the court.
But my lord, the court has held that in the read court that cannot be assessed, my lord.
This has not even been
There is
discussed.
sufficient material, my lord.
This order of the Industrial Tribunal, 30th March, has not even been discussed.
My lord, Lordship, page 21, Lordship, see, the court has taken the view the South case, my lord. Even if material is available, if different view is taken, the read court cannot be.
You're not following what I'm asking, sir.
Page 21, Lordship, see, my lord.
20?
This court has taken the consider that.
Let's see. Where is that?
Page 21, my lord.
Read.
But the apex court in case of South versus Radhakrishnan.
So what is his name?
64 Supreme Court hearing it. Page 21 of the review application.
Mr. Ratha, I don't know that you're following the question I'm asking you.
Well,
before this court, he had filed an additional affidavit.
Well,
and he has placed on record copy of the order passed by the Industrial Tribunal.
Well,
the award
Well,
passed by the Industrial Tribunal on 30th March 2019.
Well,
where have we discussed that order dated 30th March 2019? I want you to point that out.
Specifically, there is no discussion.
His only ground of review is, I placed before you an award of the Industrial Tribunal which takes a diametrically opposite view in relation to one other engineer from the same organization. And that material you've not considered. This is the only ground on which he's seeking review. All we're saying is let the writ petition be considered again.
Let it be
considered again, sir.
Limited in amendment.
That's right.
Only on that point.
Which, sir, naturally, it's also limited. Let the writ petition be heard. You also can have a chance to reply to that additional affidavit. By all means, you have to reply to it.
Because materials must be placed before the court, not the order.
All right.
The evidence has to be taken.
All right. This review petition by Nava Bharat Ventures Limited, hereafter the management bracket, it seeks the recall and review of the judgment dated 20th September 2019, passed by the division bench of this court, dismissing writ petition civil 5671 of 2019, filed by the management, challenging an award dated 26 July 2018 of the Labour Court Bhubaneswar in ID case number 4 of 2017. Paragraph. The brief facts for the purposes of the present review petition are that opposite party number 3 was working as a diploma engineer, bracket mechanical. Sorry, was initially appointed. Sorry, opposite party number 3 was initially appointed in the petitioner company as a diploma engineer trainee, bracket electrical, for a period of 2 years. And on completion of the training, was placed in the post of supervisor, bracket operation. Full stop. Due to the changed market scenario, the management decided to end his services along with 4 other engineers. And on 19 June 2015, opposite party number 3 was requested to take his full and final settlement. Full stop. A tripartite settlement was entered into by the management with the representatives of its workmen on 30th October 2012. Full stop. Thereafter, opposite party number 3 raised an industrial dispute, and a reference was made on 18 January 2017 to the Labour Court whether the termination of his services was justified. Paragraph. One of the issues raised in the labor court by the management was whether opposite party number 3 was a single quotes workman, unquote, within the meaning of section 2 bracket S, right, of the Industrial Disputes Act 1947, bracket ID Act, bracket. This question was answered in favor of the workman and against the management in the impugned award dated 26 July 2018. Full stop. The finding was rendered after discussion of the evidence led by the parties. Full stop. Paragraph. Meanwhile, another engineer, identically placed as opposite party number 3, raised a separate industrial dispute, which happened to be referred in ID case number 13 of 2015 to the Industrial Tribunal Bhubaneswar. Full stop. The Industrial Tribunal on 30th March 2019 rendered an award accepting the plea of the management that the said engineer was not a workman within the meaning of section 2 bracket S of the ID Act. Full stop. Since the two diametrically opposite awards had been rendered on the same issue, one by the labor court, another by the Industrial Tribunal, in the writ petition filed, writ petition civil 5671 of 2019 filed by the management, challenging the award dated 26 July 2018, an additional affidavit was filed on September 2019, enclosing copy of the award dated 30th March 2019 of the Industrial Tribunal. Full stop. The record of WP Civil 567 of 2019 reflects that such an additional affidavit was indeed filed. Paragraph. However, while passing the order dated 20th September 2019 dismissing the writ petition, the division bench did not discuss the said award dated 30th March 2019 of the Industrial Tribunal. Full stop. This is the only ground on which review is sought. Full stop. In other words, it is urged that the division bench failed to discuss a document which was on record in the writ petition, which had a material bearing on the outcome of the case. Paragraph. Counsel appearing for the workman in the present case urges that this does not fall within the scope of a review petition and seeks to place reliance on the recent judgment dated 18th August 2022 of the Supreme Court of India in Civil Appeal number 5503-04 of 22, bracket S. Madhusudan Reddy versus V. Narayana Reddy. Paragraph. The above submissions have been considered. Full stop. The above decision in S. Madhusudan Reddy Supra recapitulates the settled legal position as regards the scope of a review petition. Full stop. Inter alia, it was pointed out that in a review petition, open quotation, it is not open to this court to reappreciate the evidence and reach a different conclusion, even if that is possible, unquote. However, as far as the present is concerned, the management is not asking this court to reappreciate the evidence, but only pointing out that an award of the Industrial Tribunal in respect of another identically placed engineer reaching a different conclusion on the preliminary question of the definition, whether the engineer falls within the definition of workman, under the ID Act, under section 2 bracket S of the ID Act, was not discussed by this court in the order dismissing the writ petition. Full stop. Paragraph. In the considered view of the court, the said document did have a bearing on the outcome of the writ petition and ought to have been discussed with this court. Stop. This is certainly an error apparent to the face of the record, falling within the purview of a review petition. Paragraph. For the aforementioned reasons, this court reviews and recalls its order dated 20th September 2019 and restores writ petition civil 5671 of 2019 to the file of the court. The review petition is paragraph. By an interim order passed by this court, by an interlocutory order passed by this court on, so you say pursuant to an interlocutory order passed by this court on 19 January 2023, the management has deposited a sum of rupees 20,15,636 along with the calculation, which has been asked to be kept in a fixed deposit. With a nationalized bank. That amount will continue to remain in deposit during the pendency of the writ petition, and appropriate orders will be passed at the time of disposal of writ petition civil 567 of 2019. Full stop. Paragraph. The review petition is disposed of in the above terms. And then in the main writ petition, you say this writ petition is restored to file by virtue of an order passed today in review petition number 411 2019. Paragraph. The amount already deposited by the management in review petition 411 of 2019 will be continued to be kept in the fixed deposit by the registry during the pendency of the present petition, and will be subject to further orders passed in this writ petition. Paragraph. List before the roster bench on July 2023.
Okay, can I pray for an interim order because they are going on with the execution proceedings?
Or there was an earlier interim order in the main writ petition? No.
Yes, my lord. Yes, my lord. Your lordships, while
The
issuing
interim order, right. The interim order. No, there was no interim order.
Your lordship, while depositing the amount, your lordship has
That
passed it.
execution case, my lord, they have filed that.
All right. There shall be a stay of the impugn award till the next date of the hearing. Right.
Very grateful, my lord. Very great.
3rd July. Right.
Supplementary list fresh admission item number 1, CRLNC 2267 of 2019.
Item number 1, all the points raised at the time of review.
Or permitting the petitioner raise all please.
Item number 2,
None appears dismissed.
item number 3,
None appears dismissed.
item 4,
Mohammed taken on record. Dismisses withdrawn.
item number 5,
Item 5, my lord. My lord, the petitioners are seeking for a direction to quash the criminal proceeding against the present petitioner, my lord. My lord, the matter has already been settled when annexure 3 is the compromise petitioner, my lord.
This is all handwritten, sir. You'll have to go before the court. This is just handwritten. Permitting the petitioner to raise all pleas before the trial court at the appropriate stage. The petition is disposed. Right.
item number 6,
No instructions, my lord.
No instructions dismissed.
item number 7,
None appears dismissed.
item number 8,
None appears dismissed.
item number 9,
For OP2, my lord.
None appears to the petitioner. Dismissed.
item number 10,
Memo taken on record. This is not pressed.
item number 11,
None appears dismissed.
Item number 12.
None appears.
Item number 13.
My lord, item number 13. My lord, I am appearing on the behalf of Mr. Sambit Samal.
Yes, please.
As he is not well, my lord, we are praying for 2 weeks' time.
Madam, this is not come up for hearing even once. Or dispensing with certified copy. That's it. Never heard even once. What is the matter about? Tell us. Wash FIR.
My lord, actually he is not well, so I am not aware of it.
You should be. This is an opportunity for you to argue. You should know what the matter is about.
I will, my lord.
Sorry?
I will.
No. If you want a chance, we can pass it over. Will you familiarize yourself with the matter if I pass it over?
My lord, please next week.
No. You don't even have the paper book with you. That's very sad if you don't have even the paper book. At least we'll give you an order which is not negative to you. It's like permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
Item number 14.
You've taken her name.
Item 14.
None appears disposed.
Item 15.
Item number 15, 16, and 17 arising out of one case, my lord. Here 3 petitions filed to recall PW1, PW3, and PW9, my lord.
What's the case about?
Case, my lord, is a case under section 363, 366, 376, 368, 222.
So you're recalling the victim, basically.
My lord?
You're recalling the victim.
2 doctors who have examined the victim and the accused, and another is the victim. They have not been cross-examined.
Just read the impugned order. Let's see that.
My lord, it is filed after 3 years of their examination.
That's all right. The challenge in the present petition, these petitions, is to an order dated 18 May 2019, passed by the trial court, declining the application filed by the accused under section 311 CRPC to recall 3 separate witnesses, PWs 1, 3, and 9. Full stop. 2 of those witnesses were doctors who had examined the injured victim. And the 3rd was the victim herself.
So there is vital witness that is about who is that PW9 that has not been.
All right. The 3rd was third was PW9. Full stop. The application was filed more than 6 years after the examination of PW1, and that too at the stage when the case was posted for arguments. Paragraph. Having heard learned counsel for the petitioner, the court is satisfied that no error was committed by the learned trial court in declining to entertain the applications under section 311 CRPC for recalling the PWs aforementioned. Full stop. There's no merit in the present petitions. They're dismissed.
Item number 18.
My lord, the order for cognizance has been taken under section 447, 294, 354, 324 IPC.
Will permit you to raise all pleas, permitting the petitioner to urge all pleas at the appropriate stage. The petition is disposed. All right.
Item 19.
None appears disposed.
Item number 20.
Item 20, my lord, on behalf of Mr. Mishra, may be permitted to raise all these grounds.
Yeah, permitting the petitioner to raise.
Obliged.
Item 21.
None appears disposed.
Item number 22.
None appears disposed.
Item number 23.
None appears disposed.
Item number 24.
None appears disposed.
Item number 25.
Same order.
Item 26.
Item 26, your lordships, liberty may kindly be granted to raise all the pleas.
All right. Permitting the petitions.
Item number 27.
None appears.
Item number 28.
Wait, my lord, liberty may be given, my lord. I will
All
raise.
right. Liberty to.
Item number 29.
Right, item 29, Lord. I have filed a miscase for a modification order. Lordship, in the 94, the FIR number 94 is as mentioned, and 93 and 94. But both FIRs are case and a counter case.
All right. Just you say the application is allowed. Para 2 will be modified as under. And we say FIR numbers 93 and
94.
All right.
Item number 30.
None appears dismissed.
Item 31.
Same order.
32.
Same order.
Item number 33.
Same order.
34.
Item number 34, Your Lordship, on behalf of Mr. Ramdas Achari, we will raise the contentions before the learned lower court.
All right. Permitting the petition.
Obliged, Your Lordship.
Item number 35.
None appears dismissed.
36.
36 may be less. In that case, my lordship, that the complainant has lost the FIR, my lordship, that has stated that my lordship has mental and physical torture by his in-law members and by his husband, my lordship. As the case arising out of my lordship, SC/ST Act, which a notice is required, my lordship, to send to the opposite party. SC/ST Act is there, my lordship. As for the notice, if a notice is required to the opposite party, not to my lordship, then they will appear, my lordship.
No.
There is no allegation against the in-laws members. There, the present person will become to in-laws members only. That there is no. He has stated in the FIR, my lordship. There is not only the stated that he is belongs to a scheduled caste community. That is the only allegation against the in-laws members. But a notice
the petition should raise all pleas at the appropriate stage.
All right. Item number 37.
None appears dismissed.
38.
May I please, Your Lordship? Here in this case, my lord, the petitioner is the railway, my lord. Some railway property has been stolen by two persons, my lord. They have been taken to custody by Khandagiri PS, my lord. Therefore, this petition, this railway department has filed a petition to investigate the matter and to register 2CC case, my lord. And that was rejected by the Lorraine SDGM. That is under challenge, my lord.
But you have not implemented those accused persons.
Because no, they have not implemented.
It's all right. Look at page 18.
My lord.
Come to page 18.
18. My lord. State submitted that investigation of the case is yet to be reached finality, and the accused is in custody being provided by Khandagiri PS. The police has the authority to investigate the case, and any interference at this stage may hamper further investigation. The investigation of the case is almost complete. The accused is in custody. The seized articles are not produced before the court. The petitioner claims that the articles are railway property, but there is sufficient proof available on record. Well,
Insufficient.
Proof available on record to hold that the received articles are railway properties. Further, any interference at this stage may hamper further investigation. The proof regarding ownership of the articles are not ascertained yet. Confession of the accused persons before the police that they have stolen the batteries from railway workshop is no proof at all. Considering the above discussions and the fact that it has not been ascertained at this stage that the recovered articles are railway property, the petition filed by the SIRPF stands rejected. But your lordships may kindly see annexure, there is a joint investigation and that indicates that the properties are railway properties.
We have to submit proofs. The challenge in the present petition by the railways is to an order dated 22nd July.
Lordship, in the investigation, the charge sheet has been submitted. Your lordship permit me to file another petition before because
he's already done that. He's already given you permission to do that.
Your lordship, that observation, lordship may dispute.
All right. Challenging an order dated 22nd July 2019 of the SDJ in Bhubaneswar, declining to return the railway property. Alleged railway property is supposed to have been stolen by the named accused persons from a railway coach. Paragraph. As noted in the impugned order, although the railways claimed that the property stolen was theirs, there was insufficient proof to substantiate such a claim. Full stop. The mere confession by the accused persons made before the railway police could not be acted upon. Full stop. In the circumstances, the SDGM committed no error in rejecting the prayer of the rejecting the petition filed by the SI of the Railway Protection Force for return of the properties, case property. Paragraph. It's seen that the SDJM opined while declining to register a separate case under section 10/19. Declining to register a case has permitted the railways to take back the petition and present it in a proper form so that a 2C CC case could be registered. Full stop. Since the liberty has already been granted, no further directions are called for. Full stop. The petition is accordingly disposed of.
Item number 39.
None appears disposed.
Item 40.
Same order.
Item 41.
Same order.
42.
I put the
Lordship, I'm appearing for item 42 and 43. Lordship, both infructuous.
Yes, dismissed as infractions. All right.
Obliged, Lordship.
Item 44.
44, my lord, no instruction. My lord.
No instructions.
Obliged.
Item 45.
None appears dismissed.
Item number 46.
Same order.
Item 47.
Same order.
Item 48.
Same order.
Item number 49.
Same order.
Item number 50.
Same order.
Item number 51.
Same order.
52.
I may be permitted to withdraw this petition.
All right. Dismissed as withdrawn.
Item 53.
So for item 53 is concerned, it is a Belgium case. I will approve the lower court, my lord.
All right. Permitting the petitioner to raise all pleas in the appropriate state.
Item 54.
Permitted to withdraw.
Dismissed as withdrawn.
Item 55.
None appears dismissed.
56.
Same order.
Item 57.
Item 57, no instruction with liberty to file further.
No instructions dismissed.
No instruction.
All right.
Obliged.
Item 58.
None appears dismissed.
Item number 59.
Same order.
Item number 60.
My lord, allegation against the victim against the farmer. Petitioner number 1 and 2 are the parents of the farmer. Well, the ingredients of 493 and 417 is not made out against the parents, my lord. And your lordship may kindly see the 493.
Yes.
Cohabitation caused by the man registration inducing belief or lawful every man. Here is the parents. Petitioner number 1 and 2 are the parents, man.
Yes.
The relying upon the Kerala High Court judgment, the famous Katie Thomas judgment, my lord.
Can point it out to the trial courts, permitting the petitioners to raise all pleas at the appropriate stage of the trial court. Petitions disposed of. Right.
Item number 61.
May I please your lordship? My lord, cognizance under section 323, 427. Dispute between two neighbors. May I pray, can it be referred to mediation because the offences are compoundable?
If they are here already, it's fine, sir, not otherwise.
Very trivial issues.
Who is appearing to the other side?
Other side case.
Some Sushant Pradhan. All right. Although Mr. Sushant Pradhan has entered appearance for the opposite party, today none appears. The registry will inform him by telephone to remain present for the next date before the roster bench. List on 16th May, interim order to continue.
Item number 62.
62, your lordship kindly have a glance. This is a prayer for FR question. Your lordship kindly have a glance to the averments. The entire averments is like this, my lord, as if a character certificate has been given to the accused. Your lordship kindly have a glance to page 14. Page 14.
This is 498A, sir.
Para 12.
This is all 498. Unless there's a settlement, it's difficult to interfere.
Sorry, my lord.
If there is a settlement, what is the inspector state? Is there a settlement of the disputes? No.
Initially, we have lost one FIR against them. Thereafter, they have lost another FIR against.
This is a 498A, isn't it? This is 2348, which is item number.
Sorry, it might be some other. 52T.
2, 3,
Offense is under section 341, 294, 323, 325, 354, 379, and 34 of IPC.
All right.
62 item.
The complainant is a woman.
Yes, your lordship. That has been written at first information contents on dated so and so at about so and so. Complainant Gitanjali Nayak so and so in which she alleged that out of a land dispute on 5/8/2017, the OP members Kalpataru Das and his wife and 2 daughters attacked her younger brother-in-law Vikram Nayak. Though said informed
Removing
by
the sari,
registered-
took over hearings. This can't be gone into the states. Permitting the petitioners to raise all pleas at the appropriate stage.
The FIR which I have lost against them, this is the order passed by. Target.
Or it will be open to the petitioners to request the trial court.
Within 3 months, conclude the trial. He has given. This is the order passed in FIR counter FIR.
This is a 2019 order, sir. By now, it should be over then.
Both the matter have been tagged together.
So obviously, then this order has no meaning. Therefore.
That's why I pray, my lord. A direction may be given.
The petitioners are permitted to request the trial court to expedite the matter. Right.
May I say for a stipulated time period?
Not necessary, sir. The trial court will do it.
Maybe 6 months, but a stipulated time period.
It's all right.
They are deliberately not coming to the court. That's why I'm saying, your loss.
Anyway, the trial court knows how to deal with it.
4 witnesses have already been examined. They are not coming. For that reason, within 6 months, your lordship may.
So this petition is pending. Therefore, nothing moved there. Now let's see what happens. Yes.
63.
63, my lord. The dispute between the parties have been settled. The dispute between father and son. There now the prayer is for quashing of the DV proceeding. My learned friend is appearing on behalf of the wife. Daughter-in-law.
There has been some development, my lords, in the sense, my lords, that the parties are residing under one roof, of course, in different floors. And, my lords, things have become cordial to a certain extent. So, what I pray, my lords, your lordships may dispose of this case, my lords, giving me liberty, my lords, just in case, my lords, they disturb me again, my lords,
No, you file affidavits, then that's better. This can't be uncertain. At the request of counsel, the parties who want time to place on record terms of settlement, list before the roster bench. You better drop terms of settlement, sir. Otherwise, this will keep recurring. List before the roster bench on 9th May.
Item number 64.
Interim order to continue. Right.
64.
My lord, 64, I'm appearing for the opposite party.
None appears for the petitioner. Dismissed from opposite.
Item 65.
65 compromise, my lord, in local adult, my lord, by the order dated 14, 12, 19. In both the cases, 65 and 67, 65 and 66.
Where is that? Where is that Lok Adalat order?
I have already taken instruction. That order I have taken instruction. I have taken instruction, my lord. It is not in the records, my lord.
You place it on record.
So, lordship, my record may be my submission will be recorded, my lord.
Counsel of the petitioner states that matters have been settled in the Lok Adalat.
National Lok Adalat.
National Lok Adalat. He's
on 14, 12, 19.
On 14, 12, 2019, he seeks time to place it on record.
Yes, my lord.
Place the relevant documents on record. Place before the roster bench on 10th May. Right, both these matters.
Yes, madam.
Right.
Item 67.
I am for the optimal.
None appears for the petitioner. Dismissed.
Item number 68.
Passing of proceeding, my lord, on the ground of mutual decree of divorce, my lord. I'll see my lord, decree of divorce.
Counsel petitioner produces copy of an order dated 24th September 2019 passed by the Family Court Cuttack in civil proceeding number 532 of 2018 dissolving the marriage between the petitioner and opposite party number 2 under section 13 capital B of the Hindu Marriage Act 1955. Then takes from the prayer clause in that way of the matter and all proceedings consequent that hereby quashed.
Item number 69.
None appears dismissed.
70.
My lord. My lord, this is a case of 2012 and 2015. The order of decree of divorce have already been.
All right. You say Annexure 2 is copy of an order dated 10/12/2015 passed by the Family Court Cuttack and proceeding 216 for 2015, dissolving the marriage between the petitioner and opposite party number 2 under section 13 capital B of the Hindu Marriage Act 1955. That view of the matter. Take from the prayer clause and all proceedings consequent that we hereby quashed.
Item 71.
Released.
None appears dismissed.
Item number 72.
May I please? Compromise effected, my lord, at like we, your lordship kindly see. The informant.
Yes.
All right. Counsel, the informant confirms that the compromise has been entered into between the parties. The affidavit is at flag B. In that view of the matter, takes from the prayer clause and all proceedings consequent thereto hereby quashed.
Item 73.
None appears dismissed.
74.
Same order.
Item number 75.
May I please, your lordship. Matter already been settled, my lord. Your lordship kindly see page 11.
I'm appearing for opposite party 2 as well as informant, my lord.
All right. Counsel, the informant confirms that the matter has been settled between the parties. The compromise agreement is at Annexure 2. In that view of the matter, take from the prayer clause and all proceedings consequent that are hereby quashed.
Obliged.
Item 76.
None appears dismissed.
77.
77, quashing of the affair on the ground of compromise, my lord. Yeah. OP number 3.
All right. Counsel for OP number 3 confirms that the matter has been compromised between the parties. The marriage certificate is Annexure 2. In that view of the matter, take from the prayer clause and all proceedings consequent that are hereby quashed.
Grateful.
78.
And for the OP, my lord.
All right. None appears for the petition. Dismiss for non-possible.
Item 79.
May I please, your lordship? The quashing of the criminal proceeding on the ground of compromise, my lord. And the affidavit is already filed by the OP 2 and 3 is the victim and the informant.
Pardon, lordship, I am appearing in BC, your lordship. I am for opposite party number 2 and 3, your lordship.
All right. Counsel appearing for opposite parties 2 and 3.
On behalf of Mr.
Confirms that the matters have been settled within the parties. The affidavits are also on record. Affidavits to that effect are also on record. That if the matter takes the prayer clause and all proceedings consequent that were hereby quashed.
Item number 80.
Obliged, my lordship.
None appears dismissed.